All right, good morning. We are going to go ahead and start. If there is any issues, if for any reason you can't hear, I guess you won't know to be able to type in. But if there's any issues, please let us know through chat. Good morning and thank you for joining us. I am Jessica Porter. I'm the Vice President of Retirement Plan Services with BPG Wealth Management, and I am co-hosting here with BPG Partner and Vice President Alice Tang.
Hi.
We are really excited to have the opportunity to host this webinar this morning. Millions of Americans are dealing with the issue right now of caring for aging parents or elder family members, or in my case, parents-in-law. And we're seeing them enter assisted living facilities, coming in and out of the hospital, facing cognitive decline. I think in a lot of cases, unfortunately, all of the above. And seeing this happen firsthand for me is what triggered the desire to host this webinar. And there's just so much to try and navigate to figure out what facility is the best and what course of action to take, and are estate plans and wills up to date. And trying to figure all of this out puts an enormous amount of stress on the caregiver themselves. And it's made me realize why it's so important to have a support team and why we need to have access to people like our first presenter. So our first presenter with us this morning is Bill Cohen. And Bill is with Cohen Caregiving Support. He is the owner. He is a caregiving consultant, a support group leader, and has experienced firsthand how diseases like Alzheimer's can affect families. Bill cared for his mother, Sheila, for the better part of 10 years. And his experience in doing that really gave him unique perspective and the ability to help families that are going through the same thing, to provide them with guidance, for resource, and for support for self-care, which is really important and tends to get forgotten about. So Bill is going to take a few minutes. He's going to share a bit more about his story with us, and then he's going to answer some questions on financial matters, coordinating with your support team, options for housing. We also want to encourage you guys to ask questions as well. So make sure there's a little area where you can type in questions. As he's speaking, we want to make sure we address anything that you have questions on as well. So please do that. Bill, it's your turn.
Good morning. Thank you, Jessica, Alice, and good to be with you again, Taylor. So I'm going to mention a little quick question statement. Many of you may have been or are or know someone who's been a caregiver for a loved one living with dementia. And that's what I did. I was with my late mother for almost 10 years. An interesting statistic that you may not know is nationwide there are about 16 million unpaid family caregivers for families living with dementia. And that represents about $230 billion, that's with a B, billion, of unpaid care. So imagine if someone could help family caregivers go through the journey, coordinate with all the different service providers and professionals on all the different issues you have to deal with, and reduce your time, cost, and stress. That's what I do. And it all started almost 15 years ago. Otherwise, I wouldn't be sitting here today. It's an interesting story. My mom, Sheila, was living in Biloxi, Mississippi, and she was showing some signs of something. We weren't sure what, but confusion, paranoia, not handling her finances, not handling cleaning the house, that type of thing. So we were thinking that, well, and she was also trying to take care of my late stepfather who had all kinds of issues. He was on hospice. And so she was in the caregiver role and was wearing her down. We were wondering if he passed away or went into a care community of himself, would she bounce back? Unfortunately, we never got that opportunity. She lost her home in Hurricane Katrina in 2005. Needless to say, the trauma of seeing her home completely gone after surviving all the other hurricanes over the years really made her go downhill after that. Make a long story short, as far as that's concerned, she was on the East Coast with a couple other family members. I made a lot of trips back there. I immediately joined a support group through the Alzheimer's Association, which I happen to be the facilitator to today. So I've been a part of that group in either role for 12 years now. And I was already talking to a care community in Raleigh Hills. But once I moved her out here, when she was still capable of flying and some lucidity, got her situated in assisted living. So as a preface to all that, what we try to get people to do is prepare, to plan, be proactive. Don't have to make decisions short-term emotionally in a crisis, like somebody has a stroke, somebody falls and breaks a hip, that type of thing. In my case, a hurricane, not the usual one, but it happened. And that just changed everything. So after I moved her out here, she was less than a year in assisted living, which was expected. And then she was in memory care for 4 years at a care community in Raleigh Hills. Excellent care. It's the place where I wanted her to be if she could afford it and she could get admitted. Fortunately, she could. She didn't have any other major problems. A lot of people ask, well, why did she get Alzheimer's? And one quick aside, dementia is the umbrella term. There are many kinds of dementias. Alzheimer's happens to be the most prevalent one. There is no cure, there is no treatment. It is at this point always fatal. It's the 6th leading cause of death, and it's the most expensive. So we were facing that, and that's one of the things a lot of people deal with, the long journey. It's why they call it the long goodbye, because you're dealing with anticipatory grief, and that's exactly what I was dealing with. But going back to all the issues, I dealt with elder law, I dealt with the financial, I dealt with housing, in-home care, respite, long distance, quitting driving, you name it, I dealt with it, plus having to deal with all the issues of after losing the home with insurance and real estate and my step family, I won't get into that one, and the aftermath of a storm. So I was dealing with every issue. I didn't know who to turn to. I didn't know where to go. I didn't know what the resources are. And like many of you, I felt alone and overwhelmed. We didn't have much information on the internet. We didn't have resources like Retirement Connection, which is a great little guide. Maybe you've seen them around or gone online. So I could have used somebody like me, and I could have used somebody like Taylor or other professionals that could have helped me coordinate all those issues. I had to just figure it out as I went along. So she passed away. Oh, I was going to mention about how she got Alzheimer's, is that she was living in an area which is not real known for environmental practices, a lot of toxins, chemicals, pollution, things like that. She didn't exercise, used to smoke, barely walked the dog to the corner. Unfortunately, she was an accomplished artist and was a printmaker, and she was dealing with metals and acids. So we think they have been a big factor in why she did, because she had no other major problems other than slightly elevated cholesterol. I used to kid her, Mom, we're on the same minimal dose statin. Isn't that funny? Haha, I didn't know that. So unfortunately, she hung on for a long time because she had no other major problems, but passed away in 2013 at the age of 83. And if I hadn't gone through all that with her, I wouldn't be sitting here today. It became something that I turned a personal loss into a passion and what I like to call my encore career. So, and if any of you have any questions at this point, please feel free, put them in the chat room, because I like to tell about my mom's story, my journey with her briefly, but it's about what your concerns are, what your questions, what your issues are. But a caregiving consultant is a person who coordinates with all the different service providers and professionals, such as Taylor. For instance, one of the first questions I'm going to ask my clients or people in support groups, which I lead, is, do you have durable power of attorney? Do you have advance directive? Do you have a pulse? Do you have the wills? Do you have the trust? And if somebody says no, I'm going to say, that's job one. Because if you wait too long, if they become incapable of making decisions, they're not lucid anymore, it's going to get more expensive and more complicated, such as guardianship and conservatorship, which Taylor talked about. And if somebody says, okay, who do I talk to? I'm going to say, I'm going to give you the names, some vetted, good research attorneys, such as Taylor. You'll have to decide who's the best one in terms of fit, geography, cost, personality. And then if they ask, Okay, great, I'll do that. What do I put in the documents? I can't tell you that. I don't practice law. Taylor does. So, and that's the same with any other issue. I am using my personal caregiving experience and I provide advice and guidance. But if it gets into things like in-home care or care communities or adult foster homes, I'm going to work with and refer you to the best possible professionals and service providers. One thing that people should know about because one of the main questions that comes up is about housing. We think mom or dad are ready to move. Two main things here. One, you need to talk in terms of not yes or no, but which choice. Again, going back to being proactive, that if they're not getting proper care, if they're not safe, if they're secluded, if they're not getting out and having interaction with other people, that's not sustainable. So what they need to do, the family, is to talk to the loved ones, say, okay, which do you want to do? We can bring in home care, we can go to a care community. And what I usually do is, when in terms of housing, there are professionals called adult placement or senior referral specialists. You don't have to pay them a thing. They get a fee with all the care communities they have contracts with. And they do the vetting, they do the research, they know where what the vacancies are, they know who has Medicaid versus private pay, they know all the levels of care, such as adult assisted living, memory care, independent living, or foster care, or skilled rehab. And again, you don't have to pay them a fee. They will take you on a tour and they will get compensated by the community. So please keep that in mind. Those are just examples of some of the people that I coordinate with and help people navigate their journey. And that way it's objective and you know you're going to get somebody who's trustworthy. Those are the people that are on my A list, shall we say. Do you have any questions at this point?
Yeah, so we want, again, if you have any questions, anything that's come up personally for you or something that you faced and didn't know what to do with, if you have any questions, we want to make sure we get those answered as well. So please make sure to type those in the chat box there.
Because if there aren't any right now, what I'd like to do is leave it open for later, because I think some other questions will pop up. Like I said, I work with professionals and attorneys, et cetera, and financial advisors, like it says, like Jessica and Alice. And that's my role. I'm a guide, I'm a coach and navigator. You don't need to feel alone. You don't need to feel overwhelmed. There is help, there is support out there. And I highly encourage that if you're dealing with this, go to a support group. They're safe, they're confidential, and you'll find so many other people in your same situation that you'll draw support and advice from. They've been there just like I was.
I have a question. This is Taylor here. Sure. When Bill and I met to talk about this presentation, it was really helpful for me to hear from you, Bill, what the process looks like when somebody wants to work with you. How do they reach out to you? How much time does it take? What does that look like for deciding how do I get the help that I need and tap into your expertise?
Great question. So I get most of my clients from other service providers and professionals, a little bit from other sources, or of course, word of mouth, et cetera. Like so many professionals that you may have worked with, like Taylor, like Jessica and Alice, is I ask a lot of questions. I do a lot of listening. It's like a checklist, a needs assessment. And from there, we determine, what do you want off your plate? What are your main questions? What are your main problems? What are your issues that you want resolved so you can reduce your stress, reduce the time spent, and reduce your costs? Then we determine how many hours we'll need to work in your behalf, and I can work either on an hourly basis or a monthly retainer.
Excellent. So we have an audience question, Bill.
Sure.
What would be the steps if someone in your family reaches the point of not being able to travel, yet you need them to be closer to you in order to care for them?
not able to move them? I presume, is that the question?
Right. I would assume, and if you want to clarify, Danielle, but I would assume, yeah, if they have some sort of physical disability or they've reached a point where they're unable to travel,
Right.
what would be the best solution?
Right. And that's why we moved my mom when we did, because she still had some lucidity. She still was ambulatory, but declining quickly. So if you're here and they're elsewhere and you can't move them, it would be almost impossible for them to travel or move. You can work with someone like me here locally, and although I may not currently know somebody in that other area, say Cleveland, Ohio, for instance, I know how to get a hold of the resources because I have connections here and there that can put me in touch with those people, and that can be elder law, that can be financial, that can be in-home care, it can be care communities, et cetera, or even the adult placement specialists. So then we can work on a long distance basis, and that could be in reverse as well. You may be out of town and they may be here, and I could be your eyes in here as well, and we can work, if not in person, by phone and text and email and Skype or Zoom or whatever method works best.
Excellent. Thank you. So I don't see any more audience questions at this point. Again, if anything comes up as I'm going to introduce Taylor, and as she's speaking, if you have any questions that pop up, please feel free to enter them in. The second part of our presentation is going to focus more on the legal side of things. So we have Taylor Kittle of KG Law Group with us. Taylor specializes in estate planning, including probate, trust, guardianship, and conservatorship. She works with families to help through life transitions, from planning to protect young children, all the way up to dealing with difficulties caused by incapacity and death. She is going to walk us through Estate Planning 101. She's going to talk about why estate planning is so important and how to plan for both incapacity and death of family members and loved ones.
All right, thanks for the introduction. I wanted to go over a couple of things to piggyback on what Bill was talking about. First off, who are the members of your team? Anytime somebody is aging and dealing with dementia or incapacity, whether it is temporary or permanent or short-term or long-term, you need a team. Right now, part of this webinar are the main people on your team. Your financial advisors are critical in saying, what can you afford, for how long, are there other tools or products available to help you out, how do you plan for the future, because that's critical. Bill's role, as far as how we all work together, is dealing with the practical, dealing with the real life. What's the stuff that you actually need to get done? How do you have eyes and ears on the person who needs help? How do you gather the resources so it's not 100% on your shoulders, because that is not sustainable for any human being. I am this narrow pinch hitter that is critical, but more limited. I do the legal stuff so that the people around you can do what needs to be done. So if someone does not have a power of attorney or an advance directive or legal authority to make decisions that need to be made for the person who is dealing with incapacity, you're going to be spending a lot more time, and you're going to hit these barriers where you can't talk to the bank. The bank won't give you information. You can't make changes to the retirement account. You can't purchase that annuity or whatever else it is that's best financially or best health-wise, because you don't have the legal documents that are in play. So that's my role. I welcome questions throughout. I talk about this day in and day out, so I can just keep talking for as long as we need to, but I want to make sure that I am addressing the questions that you have and the reason that you're here. So feel free to pipe up at any time, and I will try to address them. A quick note about my materials. I will probably not cover everything in the materials, but I want to make sure that you have things like the critical terms. Who is an agent in the power of attorney? What is an advance directive? Are there other documents? So please consider my materials to be resources for you, even if we don't go through everything in detail. We'll talk more high level and a few other pieces along the way.
So I'm going to jump in. We have an audience question, and I'm going to pose this to everybody here. Are you familiar with a financial product that the audience member believes is called a Medicaid annuity?
I think my experience is a few years back, we were contacted by a trusted partner and attorney where actually the father is going south in health and they want to qualify for Medicaid. And knowing that there is a limit in the government's eyes about how much asset this father can hold in order to tap into the Medicaid resources. So what the attorney was suggesting is to put some of the funds that the father has from the bank, which is in money market, into an annuity and quickly, this is an immediate annuity, meaning it generates income right away, giving up the principal. I can't even remember it's 50,000 or 60,000, giving up the principal and generate an income stream. So it automatically eliminate that block of asset from under his name, and then he start qualifying for Medicaid's help in the nursing home. So that's my experience.
Okay.
To piggyback on that, and there's one slide in here briefly about Medicaid, but I'll jump to that topic before we dive into the others because I'm sure that's on the forefront of most people's minds. Medicaid is, as many of you probably know, a needs-based government program that's different than Medicare. Okay, so Medicaid has limits on what assets you can receive, and that's what Alice is referring to. And so a lot of people come to me and say, how do I qualify for Medicaid? And I look at their assets and I say, you actually have a lot of money, and there are some catches. So you generally can't have your cake and eat it too. Medicaid, the needs-based cap is with some exceptions, and this is more nuanced, but generally speaking, you can't have more than $2,000. $2,000 is not a lot of money. Medicaid is set up for people who really, truly do not have any resources to self-pay. The general strategy is to spend down, and there are ways to do that in a thoughtful and strategic way so that you have other assets that are excluded from that total amount so that you have things like a laptop and good clothes and maybe remodeling the house, and there are a lot. This could be a very complex topic, but generally speaking, there are two important principles. One is you have to have under that asset amount, and you can't just give your stuff away. There's a 5-year look back period where they look back and say, did you make any gifts? Did you give anything away that wasn't for fair market value? So you can't necessarily cheat through the system. The other piece is even if you said, okay, I'm going to give away all of my assets, I'm going to wait 5 years, my kids will pay for me, and then I'll qualify. There's a lot of unknowns there. 5 years is a long, long time. Another piece of it also is that even if you were to qualify for Medicaid, if you were to use something like there are income cap trusts, there are self-funded special needs trusts, there are a lot of ways that we can create a situation so that that's not your money anymore, but there's almost always got to be some kind of payback provision. So the estate recovery unit at the state of Oregon level or whatever state you're in will actually take money from your estate after your death. So it's going to come out one way or another. The state will get paid for the resources it gives to you unless you truly don't have money. So there's a lot more to talk about and unpack there, but I wanted to just clarify that because that is a really important piece. And another very important piece, regardless of your asset level, is just understand the foundational elements of that and know if you're going into any kind of care facility, do they only accept private pay? Not all care facilities, and Bill could be a great person to help you navigate this question, not all care facilities accept Medicaid, and memory care is expensive. So if you think you're doing fine and you've got $500,000 in the bank, or your parents do, but it's going to be $10,000 a month, and maybe they live for many, many years, there's a point where you probably don't want to move them. So you want to think about think ahead. How many years will this last? Talk to your financial advisors like Jessica and Alex and say, what am I really dealing with? And make sure that you choose a facility that will eventually qualify for Medicaid if that's even on the radar.
I can add one note that many communities will allow you to start on private pay, and if you run out of funds, they will not kick you out while you're qualifying for Medicaid.
Mhm.
So that's, again, a question to ask. And also, when you work with the adult placement folks, they would be able to assist you on that question.
Mhm.
Excellent. Thank you.
Good question.
All right, so quick overview, the timeline for estate planning administration. The critical key here is plan. Plan ahead while you can. Maintain means make sure it's updated, and then administration, I'm just going to pull up all the terms here. Administration begins at an event, so whether that's an incapacity or death. Death is black and white. There's a proclamation of death. It's at a certain time on a certain date, and then you move forward with the legal process from there. Incapacity is much more difficult. You don't necessarily have this moment in time. Sometimes you do. Sometimes it's a stroke. Sometimes it's a fall. Sometimes it's some other triggering event, but often it is a slower decline that's harder to navigate. So incapacity issues are, there's a lot of gray area. There's a lot of sticky topics. But legally speaking, we'll be talking about incapacity as something that is determined, something that even though recognizing it could be fluid. So plan ahead, because it's never too late until it's too late. You can't go back and retroactively create a power of attorney once someone has lost capacity. Once somebody has gone over that threshold and they don't know necessarily where they are, what their assets are, who their children are, there's some basic questions where I as an attorney assess, does this person know what they're doing? Are they doing this of their own volition? And if they're still able to acknowledge and understand the nature and consequences of their actions, legally speaking, we could still do a power of attorney. But if they're past that point, then it's too late and you have to go to a court process, which is a lot more time consuming, a lot more expensive, and not just a little more expensive, a lot more expensive, both in setting it up and continuing the ongoing administration. And it's generally just not fun. It's not private, everything is public record, and it's very stressful. So we want to avoid that. And having the power of attorney and advance directive are some of the most critical documents, and also relatively simple in what they do.
So Taylor, I think that's a good time to jump in with our next question. So we have an audience request: discuss the duties, opportunity, liability, and risks of agreeing to be a power of attorney. And I know you have this as a part of your presentation, so I don't know if you'll jump into that a little bit more.
Yeah, I think we can go ahead a couple of slides, and again, spend a little bit more time for those of you who are interested, as far as we've talked a little bit about incapacity, the fact that it's fluid, what kinds of issues and options do you have to decide, for example, with the power of attorney? Who would be the agent is the critical piece. Who would be the healthcare representative under the advance directive? I want to make a point before we go into the power of attorney specifically, that when you are planning ahead, you can craft a power of attorney and to some extent an advance directive to meet your own needs. So if you do a court supervised process, a guardianship or a conservatorship, there's no flexibility there. You're not going to limit under most circumstances. You can have a little bit of flexibility, but you're generally not going to be limiting the conservator or guardian's powers. But with a power of attorney, you can create something that makes you more comfortable. So a classic example is, if you name an agent in a power of attorney, does that agent have the ability to make a gift? So gifting strategies are big for reducing estate taxes, but are you comfortable with the person that you're naming being able to freely gift, and to who? How much can they give out of your estate? Are they going to give themselves gifts? Are there other legal ramifications of that? Or is your intent, you know what, $10,000 per grandchild per year to reduce estate taxes is what I want? We need to craft that. They need to have legal authority to do that, but within your comfort level. I will go, we have the advance directive first. So let's jump ahead to the power of attorney slide. There we go. So a really critical point that I appreciate was highlighted in the question. The question says, like, duties, opportunities of agreeing to be a power of attorney. You can be appointed an agent without agreeing. Okay, so anybody who has a power of attorney could name you as an agent and you may not even know it. This is really important because it does come as a surprise. You do not have to agree to be appointed. You do have to agree to start taking action. You can resign. You're not going to be forced into that role. But again, you may not know it, so it's really important to ask. There are many, many families who are surprised. Let's say there's multiple children in a family and dad loses capacity and they find a power of attorney. And once upon a time, when that power of attorney was drafted and it was never maintained, they named older sister. Well, older sister is now in jail and on drugs. And little sister, who's been the caretaker for 10 years, doesn't have any authority, right? So there are surprises that come out. This wasn't something that they would even be aware of or have to have knowledge of. So ask. Okay, so duties, opportunities, liabilities, and risks. Generally speaking, the main duty is that you are an agent. The agent is it's not a power of attorney is the actual document. An agent is the role of the person empowered by the power of attorney. The agent has duties to the principal. The principal is the person who creates the power of attorney. And those duties are generally to act in the best interest of the principal. So what would the principal want? What's best for the principal? Not for everybody around the principal, but for the person. So let's say we're dealing with a dad who's incapacitated, has dementia, is in memory care, and daughter looks at the estate and says, well, there's plenty of money here. You know, there's no way he's going to live more than 2 years. We've talked to, Jessica and Alice, and they say that we've got enough money for 3. I'll just start gifting money to myself and my kids. That would be a violation of their duty to do what's in the best interest of the principal, which is to make sure that there's enough money for that person to survive and maintain the level of support that they need. Now, if it's $2 million and they could last for 30 years and they're in their 80s, you're in a better position where maybe there's some benefit to reducing estate tax liability. But you have to do what's in the best interest of the principal and what basically they would do for themselves if they had capacity. Liability-wise, you are liable for your actions that violate that principle. So if you have somebody who in their dementia has become combative, this is a question I get a lot, and maybe they're hitting their caretakers. You as their agent, you are not liable for that. You're not able to control that. That's not something that's within your power. If they are hitting a caretaker and the caretaker is upset and wants to sue them, that's more complicated, but generally speaking, they're not going to come after your personal assets, right? That doesn't open you up personally or your own estate to that person's actions. But if you started misusing the funds and somebody sued you for it, you can be sued for your own actions. As far as the importance of it, it is the critical document for avoiding a court-supervised conservatorship. There are some times where you may still need a conservatorship where the power of attorney. Yeah, as Georgia.
Would you mind differentiating or explaining what is conservator and what is guardianship?
Yeah.
So probably some of the audience would like to know before we continue.
Thank you, Alice. I appreciate that. So a guardian is in control of the person, and a conservator is in control of the estate. In other states, including Washington, they call it a guardian of the estate or a guardian of the person, but there's almost always 2 different roles, separated by basically money and financial instruments, and then healthcare decisions, placement, residential care, things like that. Yeah.
And getting back to when you were giving the example of the caretaker, if they're hitting, that's not their role, but if they're also on the advance directive, the healthcare representative, they may make a decision about, I think we need to change the caregiver. Maybe they're not interacting well with my loved one.
Yes, exactly right. And so having the authority to make decisions about both aspects of someone's care, or at least having someone in each role, is really important. So if someone says, there's no planning documents, but my dad has lost capacity, all we really need to do is deal with the money, I will always recommend that you also be appointed, or someone be appointed the guardian, because you don't want to retroactively say, oh shoot, I need to move them. I don't have authority to do that. The only authority I have is over the money. So having both roles filled, either through planning with an advance directive and a power of attorney, or through a court process, which is guardianship and conservatorship, someone needs to have the authority to make those decisions. I want to spend a little bit more time on a couple pieces of the power of attorney because it is so important. One of the most important pieces of power of attorney is the fact that it is revocable. If someone still has capacity, they can create a power of attorney, but they can revoke it while they have capacity. So if life circumstances change, you are not stuck. Nothing you do while you have capacity is in stone. This is really important when you talk about, if you're the caregiver, when you're talking with your parents or your brother and sister or whoever it is who you anticipate may face a period of incapacity, it's important that they're not threatened by your conversation with them. So how do you talk to somebody about having their estate planning documents in order is a critical and difficult piece of it. It can feel like, for a lot of people, I don't want to ask because I don't want them to think I'm only out for their money. I understand that, I appreciate that, but there are ways to talk about it where that is clear without simply not bringing up the subject. How do you make this subject disarming so that you also say, I'm not just after controlling your money? A power of attorney, you can say, like I talked about a little bit earlier, you can limit my authority. I just want to be able to step in and pay your utility bills if something happens. I want to be able to, what if it is that we keep you in the house? And how can you basically negotiate some terms so that that person is comfortable and doesn't feel like you're taking over their life? That is the number one, that loss of control is one of the number one reactions I hear from people whose capacity may be declining, but they are still very much aware that they want to, let's say, drive. They want to pay their own bills. They want to maintain that autonomy because how scary is it to lose that? So how do you talk about it when you're dealing with somebody who's defensive? Understandably. One of the pieces is telling them, look, a power of attorney can be revoked. If you don't like what I'm doing, you can take it away. Another piece of it is to make it really clear that the principal still has power to manage his or her own finances. So if you say, look, Dad, I really need you to execute a power of attorney because if something happens to you and you have a stroke, I want to be able to step in. Can you show me how you write checks? But I'm not going to do it until you ask me. Can you show me, what utilities you pay? But I'm not going to do anything until you ask me. By signing something, you are not just giving away authority, and there are ways to even limit when is this effective. Maybe it's only effective upon that person's incapacity. Maybe it's effective immediately, but only for certain powers. There, again, you can make it very simple, but you can also customize it so that that person doesn't feel threatened and doesn't feel like their autonomy is just being ripped away prematurely.
In my mom's case and my stepfather, we started slowly with things like payable on death on bank accounts or getting my name on it. After the storm, then they did put me on as power of attorney and advance directive, etc. So yeah, it was a slow thing, and I even helped with the taxes. I said, Mom, would you like some help with this? Yes.
Right, and think of it more as a personal assistant.
Exactly.
Than a fear or threat. And I will say, just thanks for that comment, Bill. One common reaction is, why can't or should I just put myself or my child or whatever on that person's bank account? That is a critical difference between having a power of attorney and being a joint owner is a very, very important distinction. If someone is simply put on a bank account, that money is now their money too. So let's say that there's a money market account and it's $100,000 and they say, you know what, I want to avoid probate, or I want to, manage this for you, Mom, put me on it. Upon that person's death, well, even before that, but anytime that co-owner, who's not really supposed to be a co-owner, could just take all that money. Upon the death, it automatically transfers to that joint owner, which could defeat or not be the intention as part of the estate plan, because it's not an equalized gift among kids or whatever else the reason might be. But another thing people don't think about is, what if, let's say, daughter is on a bank account with mom, and daughter gets in a car accident and it's her fault? That is an asset of daughter's. So if person that she, is suing her wants to take her money, mom's money is now available as part of her resources because she is a joint owner on that. That is scary. For when I do not recommend, except in very, very limited circumstances with very limited liability, that people are joint owners, because it so often is not what they actually intend. If you have a power of attorney, the agent's name can be on the bank account designated only as a power of attorney. That avoids all those issues. It's very clear it's not their money. It's very clear that it's not part of their own personal estate. And it keeps the control, has all the benefits of having the agent be able to work with that asset without any of the drawbacks. So that's really how a power of attorney should be used.
In the situation when the daughter is married and contemplating or considering a divorce.
That's another excellent example of if someone else is on that could be an asset subject to that person's divorce. Mm-hmm. I want to jump to the advance directive, which is back a slide, because this is the other critical capacity planning tool. So Oregon has an advance directive that is a standard form. You can download it online. When I go through advance directives as part of my process for estate planning, it is the same form. Same with every other attorney. It is not something that you have to pay to do. It is a slightly confusing form, but you can talk through your doctor. You can, with your doctor through it. You can look at different instructions online. This is something every single person should have, and it doesn't have to cost you anything. I do it as part of my estate planning package with a will, power of attorney, advance directive, and sometimes a trust, depending on the situation, because I think everybody should have it, and it doesn't cost more than it would if someone says, well, I already have mine, then it's the same price. So it's not something that is kind of an upcharge.
And an important difference between the power of attorney is the advance directive is it does not need to be prepared with an attorney, does not need to be notarized, just needs to be witnessed. You can do it on your own.
Exactly right. Exactly right. And who is interpreting the advance directive? It's typically a doctor, not a judge. So if you are dealing with a strictly legal document like a will or a power of attorney, where you're dealing with banks and judges and more conservative institutions, it is really important that document, because it is so powerful, is prepared by an attorney, and not just any attorney, but an attorney who actually knows what they're doing. So if you're talking with, not to pick on bankruptcy attorneys, but let's say it's a criminal law or a bankruptcy attorney, and they say, well, sure, I can draft a will. That's really not that different from you downloading a form online. That doesn't mean just because they have a JD behind their name that they know how it works and they have experience with the practical aspects of, is this enforceable? Is this going to do what I want it to do? So just pay attention with who you're meeting with, have an attorney you trust and feel confident in. With the power of attorney with a will, it is much better not to do it yourself. I am all for self-help. I do a lot of things myself, but it's different than building a fence. If you build a fence and the fence falls down, it's not that hard to pay somebody to fix it, and it probably will, not be that much more out of pocket. But if you don't do a will correctly, you're not going to know until it's too late to fix. So it costs, a lot of my practice now is actually fixing do-it-yourself estate plans, and it costs a lot more than the initial upfront costs when it's drafted well and clearly. So as far as saving costs, it saves money to pay an attorney ahead of time and do it right and know that your intention is enforceable and going to be followed. So back to the advance directive. Again, this is a little bit different because it's a doctor who's interpreting it. So you want to make sure it's really clear that the healthcare representative, the person appointed to make decisions on the principal's behalf, can be contacted. Don't just put their name, put their phone number. If they have 2 phone numbers, put both phone numbers. If they have an email address, put the email address. It doesn't hurt to write all this information in, because the basic job of an advance directive is to let a doctor get a hold of somebody who can make decisions on your behalf. The advance directive is a little bit confusing as far as life support and tube feeding, but at the end of the day, what's really important is that you're authorizing these people to make decisions on your behalf, so that it's somebody you trust and not necessarily a doctor that you don't know. In other states, this can be called a power of attorney for healthcare. It can also be referred to as a living will. There's a lot of documents out there that help through these decisions. Like one of my favorites that is unfortunately not valid in Oregon is called 5 Wishes. Those documents, anything you find online, can help you think through what is quality of life to me. At what point do I want to feed your life support? Those aren't legal questions. Those are incredibly personal and very important for you to communicate to your loved ones, so that when it's time, hopefully not under a stressful circumstance, but if the situation arises, your loved ones can look back and say, I know what they would have wanted, because that takes the stress away. It's not going to be clear in the advance directive because you don't have a crystal ball. You don't know exactly the circumstances under which you'll be making those decisions.
I can give a very clear, convincing example of that, and without getting into names or the politics of it. There was a famous case about 15 years ago about a woman in Florida who was on life support. It was in the news all the time, and after the storm and we did the advance directive, I asked Mom, do you want to end up like so-and-so? She said, absolutely not. She was very clear that she did not want those measures taken, and that was my guidance and what we put in the document going forward to the end when we did the polls, as you will talk about the physician's order for life-sustaining treatment. That was my guidance all the way to the end. I did not have to make those decisions about end of life.
Right.
She had already made it for me.
And to communicate that is critical, because some people assume, rightly or wrongly, that their family just knows. Well, they know me, they'll have a good idea, but when you're under stress, when your kids are under stress, they're dealing with their own emotional grief, their own fears, it is very difficult to step back and say, well, empirically speaking, this is probably what she would have wanted. You need to hear that from that person, say, I do not want my life to be prolonged, I want to die naturally, whatever the words are to give the people making those decisions reassurance. Very, very, very important. The POLST, as Bill mentioned, is a different document. The DNR, or the Do Not Resuscitate, is also a different document. Those are both things that you should talk to your doctors about, or you should have your parents talk to your doctors about, or whoever it is. Every single person should have that conversation with their doctors. Whether you actually fill one out is up to you and your doctor to decide. These are not documents that you make with an attorney. They all cover different aspects of the same thing, meaning healthcare decisions, but a POLST is a physician's order for life-sustaining treatment that can only be prepared and signed by a doctor. There's a central registry, which is really helpful, but some doctors take a position that every single person, regardless of age or ability, should have a POLST. Other doctors take the position that only if you're faced with, likely long-term incapacity or you're over a certain age do we start talking about it. So if you have any questions, talk to your doctor. From a legal perspective, the only thing I would really clearly emphasize is do not have these documents contradict each other. Make sure that you communicate what you want. So if you have a healthcare representative given instructions in the advance directive, I want life support and tube feeding for as long as possible, but you also sign a do not resuscitate. It's going to be really unclear so what do we do? Do we only wait until they have to be resuscitated? Not to, but in the meantime, it's not clear. And at the end of the day, all you want is clarity, right? You want your intentions and generally speaking to be communicated well. So go talk to your doctor about what documents you should have, but try to make them consistent, because it is a little confusing to have multiple documents for similar situations. Are there any other questions on the advance directive and power of attorney before we move on to a few other topics? All right, I'm going to talk a little bit about guardianship and conservatorship. We don't have a lot of time left, and so I'm not going to go into some of the other topics. We already talked a little bit about Medicaid, but really about planning for death. Since this is more about caregiving, I think the incapacity is the priority here. So I want to spend a little time talking about what if you don't have a power of attorney? What if it's too late? What if you have somebody, this happens also, where they did all their planning ahead of time, but now they think they still have capacity, but they don't. They want to revoke their estate planning documents. They are, maybe they did some planning ahead of time, but now they're defeating all their own planning with not understanding exactly what they're doing. So for example, I had a client who came to me because he said, my daughter's trying to control my life. I don't want to do this. I don't want this. I had this whole situation in place with my accounts. I have taken all the money out and I have put them all in new accounts in my own name because I want to control them, and she is evil, and she is, and going on this whole thing. Well, it took me a couple of appointments to realize that my client had a significant traumatic event and did not have the capacity to manage his own finances. This was an interesting situation for me to deal with as far as how do we negotiate with daughter, who actually I think had very good intentions of helping. How do we negotiate with daughter so that my client does not feel like he's lost his autonomy and control and power, but he's already gone ahead and defeated all the planning that he did when he had full capacity. A guardianship and a conservatorship is basically the court stepping in and saying this person has some or all legal authority over this other person. That's what we had to do in this situation, but we did some fancy footwork on some limitations under the circumstances. So there can be times, the point of the story is that there can be times where a guardianship or a conservatorship is necessary even when those documents are in place. But most of the time, if you have mainly that power of attorney and advance directive or revocable living trust, most of the time, those documents are all you need to keep this out of court. So let's say there's no planning in place and someone has either an event or a slow decline. There's a point at which that person cannot manage their own finances, cannot make decisions over their own health care. Maybe another thing I hear fairly frequently, and I'm sure Bill has seen this, is when maybe mom or dad live farther away and all of a sudden kids go back for Christmas and realize that there's a path. There's one clean shuffled path through the house and everything else hasn't been touched for a year. There's debris that's been accumulating on the kitchen counter. There's old rotting food. And all of a sudden you look and you say, oh dear, something has changed. If mom eats the rotting food that she thinks is fine, there's going to be some major issues. What do I do now? That's where you need to talk to an attorney and say, does this person meet the level, meet the criteria for a guardianship and conservatorship? Because the state takes this restriction on rights very seriously. It's not just mom's making decisions I wouldn't make. Right? So if mom is making donations of her money to different charities and you're going, oh, I don't know, are those abusive sweepstakes that are taking advantage of her? Or is that something that she really still has the power to make the decision to do? So this is sticky, it's difficult, and it really depends on the circumstances. The process basically is you file a petition saying, here are all the facts that support why this person can't make decisions for themselves. You have to give notice to everybody who's closely related or living with that person. They have an opportunity to object. You have to give personal notice to the person called the protected person or the respondent, and that's a person who needs help. And they have an opportunity to object and say either, I don't want a guardian, I don't need one, or I don't want you to be the guardian. It is an opportunity for siblings to come forward and air out their dirty laundry on who should be in control of mom's finances, who should be the one deciding placement. Well, mom should live with me, but you live in New York. Well, mom should live with me. I have the room, I have the space, I have the time. It is the number one factor in the cost is how well the family gets along and whether that person who you're looking to help is going to object to the guardianship and the conservatorship. In the best of circumstances, unless there's some temporary and emergency situation, we're looking at, I would say, 1 to 3 months before you actually have authority to step in and do something for somebody. So there's a significant gap in time. With a power of attorney, you don't have that gap. Cost-wise, I'd say it's easily, even in the best of circumstances, 10 times as expensive to go to court than it would be to have a power of attorney up front. Another thing that people don't realize is once you are established as the guardian or conservator, the court will supervise that for the rest of that person's life or until they regain capacity. So you're not just talking about a one-time cost, you're talking about an annual check-in, review, and accounting. If there's a conservatorship, every dollar that comes into that person's estate, every dollar that goes out of that person's estate gets reported to the court every year. There's often a bond that's required to make sure that you don't run away with the money and other costs. So it ends up being very time-consuming and very expensive, and unnecessarily so if you have the ability to plan ahead of time. So not making this fear-based, but it is really sad for my clients who come in when they've missed that opportunity to plan. Well, and actually, I think that might be a good breaking point. If we have any other questions, or Bill, if you want to throw anything else in, I think we've kind of hit the high points as far as the incapacity planning piece.
And I do want to mention too that if, I know we kind of skimmed over a couple of these slides, if you click under handouts, we do have a PDF copy of all of these if you want to save a copy of that with the information. And feel free to, excuse me, to reach out afterwards to Alice or myself. We can put you in touch with Bill or Taylor, and I'll actually skip to the end because I believe we have their contact information. We want to make sure you guys take that down if you need it. Are there any other questions? I want to make sure we don't miss anything. If anybody had any questions about Bill's presentation, Taylor's, anything that came up or came to your mind. I don't see anything, so thank you guys so much for joining us. We, as a team at BPG, we do a lot of financial planning for our clients, and financial planning really serves as a roadmap. What we have to realize, though, is that when creating a roadmap, things like this come up, and it can throw you completely off course. And that's why for us, it's so important to have planning partners like Bill and like Taylor on our team and on your team to make sure that we have a plan for that. So thank you, Bill and Taylor, for joining us. Thank you, everybody who had questions and participated. Again, if you need anything or have any questions and want to follow up, please do so. Enjoy the rest of your day, and thank you again.